the lawyers can charge you more for explaining what these things are as opposed to just handling the case straightforward. The thing to keep in mind is you don't necessarily have to show direct negligence on the company. You just simply have to show that the individual was in the course and scope of his employment at the time that the negligent act occurred. So in other words, I may be out at a seminar for purposes of marketing. That would be considered to my firm to be within the course and scope of my employment. If I get in an accident while I'm driving back to the airport, I'm still considered to be in the course and scope, so my firm could have liability for my actions, my negligent actions. You also have a second theory of liability that can be pursued against companies, and that can be direct liability for the negligent action of the company itself. If I have a history, for example, of alcohol abuse and I don't have a driver's license, but my company has not checked my background, but still allows me to rent a car and go on these trips where they know that it's necessary for me to rent a car, there could be a separate theory of direct negligence against that company. Most of you probably already checked the backgrounds of your drivers. Your CDL drivers, you know that you have to check the backgrounds. But we also recommend that you check the backgrounds of all of your drivers, whether they be CDL or not. If they're going to drive a vehicle in the course and scope of their employment, you want to know and you want to make sure that they have a valid license and that they do not have some issue that should preclude them from getting into a vehicle. We talked very briefly about use of cold medicines and things of that nature. That's almost impossible to determine on a day-to-day basis whether someone has that issue. But if we have someone, for